Hi, welcome to Law 2020 Online, Immigration Law Shape the Debate, sponsored by Trinity College London, with me, Lisa Donald, Adam Pipe and Priya Solanki. In this live session, you can put your questions to Adam and Priya and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within 48 hours, so please keep an eye out for this. For those of you who don't know me, my name is Lisa Donald and I am Head of Business Development and Marketing for Trinity's Secure English Language Testing. During lockdown, we transitioned into the new government contract to provide CELTs for the UKVI, and we are proud to be market leaders in providing this service. We take pride in looking after your clients in our centres and have a great depth of understanding of the stressful journey and the high stakes involved in the visa process to whatever route they are taking to remain in the UK. We acknowledge and have compassion towards that all of your customers, clients are not the same and have differing needs in their journeys, and we work hard and are experienced in offering a tailored service to your clients as they take their secure English language test. More information on Trinity College London can be found on the online exhibition at thesolicitorsgroup.co.uk. So let's introduce Adam to you now. Adam has been a barrister since 1999 and practices in all areas of immigration and asylum law. For many years, Adam has been ranked by chambers and partners as one of the leading immigration law specialists in the Midlands. In 2016, Adam was part of the Bar Standards Board's Public and Licence Access Review Task Completion Group. Adam was shortlisted for Barrister of the Year at the Birmingham Law Society Legal Awards in both 2013, 2014 and 2019. As part of the Law 2020 Online, Adam's sessions included immigration, asylum and human rights update and Article 8 update, children, entry clearance and Chickwam. To introduce Priya. Priya was called to the bar in 2008. She practices from One Pump Court Chambers in London. She's a busy and experienced specialist in immigration, asylum, human rights and nationality law. For many years, she's been cited as a leading junior immigration, including business immigration in the Legal 500. The directory states she is tactically astute, good under pressure and very persuasive in court. Priya has a particular interest in the experience of cases involving gender, violence, modern slavery, mental health issues, vulnerable clients and deportation. Priya's sessions for Law 2020 Online included deportation case law update and health in immigration law post-AM Zimbabwe. So to kick off, we will start addressing some of the pre-submitted questions we have been receiving from you. I think we've got one here to start. What are the law updates in regard to EU family members following Brexit? Who'd like to answer this, Adam or Priya?
Yeah, I'll have a go at that. That was a pre-submitted question that both Priya and I have had a chat about, and probably you could do a webinar in and of itself on Brexit, the EU settlement scheme and the regulations. But the EU settlement scheme carries on. So it's open until the 30th of June next year. So if you qualify under the settlement scheme, it's worth making applications under the settlement scheme. Certain things like extended family members, you'll still need to apply under the EEA regulations first, and with the transition period ending at the end of this year, I'd encourage people to make applications under the EEA regulations. Priya and I had a discussion this morning about Zambrano issues. Obviously, there's an issue coming up with Zambrano. We've probably talked before lockdown, when we were having these sessions in person, about the Home Office insisting on people making human rights application before making a Zambrano application. Now, they got no real legal basis for this. They try and cite the Court of Appeal in Patel, but I think they're mistaken. And certainly when I've got to appeal, the Home Office presenting officers have had to abandon this point and accept that it's not a requirement under the regulations. But I noticed there was a post on free movement recently, and they've looked at the statistics under the settlement scheme, and the sort of biggest category for being rejected is this Zambrano category. So I think we're going to have to look tactically when you've got Zambrano clients, whether they want to make a human rights application, which has a huge cost and is more difficult and may not get a right of appeal, or whether you want to make an application under the settlement scheme or the regulations and try and deal with this matter on appeal. One thing I did, just thinking about this, and forgive me for looking down at my iPad, there's a case called Amari. It's a case from 2020, case number 124, Amari, and that was 2nd March 2020. And that said, any EEA regulations appeal is not treated as abandoned if you get status under the settlement scheme. So if you've got a case under the settlement scheme and you get settled status or pre-settled status, you still can carry on your EEA regulations. I suppose in some cases it may be a quicker path to settlement, and there may be reasons why you carry on. So that was a bit of a quick answer, Lisa, but I suppose otherwise we'd need to spend the hour going through the settlement scheme, the regulations, and looking at what's happened. But that's a sort of brief update of what's happening with European law post-Brexit.
Okay, so Adam, we've got another question for you now. So how would you make a Chickwam argument in the light of UNAS? Yeah,
it's a real issue at the moment. For those of you, I know there are people online today who've watched our webinars. There may be people who are just sort of tuning in for the free content, and I'd encourage you perhaps after this to go and get the webinar so you can look. And one of the things I go through is the case of UNAS, which was the upper tribunal case. Let me give you the citation. It's number 129 for 2020. This was a lady who was a Pakistani national, lived most of her life in the United Arab Emirates, came in to join her partner. She came in while pregnant. He had 2 British children, I think, from a previous relationship. It was accepted in the upper tribunal there were insurmountable obstacles to family life continuing outside the UK, and it wouldn't be reasonable or proportionate for the family to be permanently separated. But they found that they'd not been truthful. Obviously, her credibility in terms of her intentions coming in as a visitor, also the intent or the credibility of their evidence as to whether the financial requirements would be met on an entry clearance application. The tribunal thought they would, and they thought an entry clearance application would take 4 to 9 months. Now, we all know that should set alarm bells ringing straight away, that everybody who's gone through the entry clearance process knows it takes much longer than that often. And I think there's a lot of speculation, especially in a coronavirus world. And maybe UNAS, the actual client, I wonder if they've probably applied to switching country now since coronavirus. But what UNAS said is that the 117B factors must still be looked at. And there may be cases where it's still in the public interest for somebody to apply for entry clearance. And to be fair, her immigration history was nowhere near as bad as those who were cited as examples in the original Chickwam case by Lord Brown as examples of people who had abused the system and perhaps should go back and join the queue. So I think it represents a hardening of the approach to Chickwam. And I've certainly had cases since UNAS where the Home Office come along and waive UNAS, or in directions that the CMRs we've been getting since coronavirus, judges have said, well, UNAS applies, you're going to have to look at this. So I would show in your application how you would meet the entry clearance requirements, because if you don't meet the entry clearance requirements, Chickwam doesn't bite. I would argue about the best interests of children, perhaps look at the timescales involved for entry clearance, the effect of separation, and maybe any particular compassionate factors. If you've got, say the British spouse here has got health conditions or something that would impact them particularly, why it's disproportionate in those circumstances. So it's not a fait accompli. I think you can still argue it, but you're going to have to, just because you'd meet the entry clearance requirements doesn't mean your Chickwam argument's going to succeed. You're still going to have to engage with those 117B factors and show why particularly there shouldn't be a requirement for you to apply for entry clearance in those circumstances. I appreciate I've been talking a lot. I don't know, Priya, if that resonates with your experience in Chickwam arguments at the moment.
Yes, absolutely. The only thing I was going to add to that, Adam, is, I mean, I've had a case recently where the applicant had an application pending for about 6 years. And in that time, that was when he met his partner, moved in with her, and they ended up getting married. So when arguing UNIS, we've relied quite heavily on the delay from the Secretary of State in saying that actually, because public interest is important looking at UNIS, it clearly wasn't so important to the Secretary of State to remove this client. And it's in that period of time that he's established this relationship. And so really he most certainly shouldn't be required to leave the country and make an entry clearance application because of the Secretary of State's inaction.
No, that's excellent. They're using those delay factors, which we would use to reduce the public interest and give more weight as an argument to support a Chickwam. No, that's really helpful. Yeah, Lisa, what's next?
What's next? So what will happen to surrender sing route until when it will continue on, or will it be discontinued along with the EEA settlement scheme?
Good question. I'll start, and then maybe surrender sing is covered within the EU settlement scheme, so you can make a surrender sing application. The person would need to have probably left, the British citizen would need to have gone to the EU state, I would have thought, before the end of the transition period, I think, in order to engage the surrender sing provisions. For those of you who watched my webinar, I'm sure, I need to check my own webinar slides, that I referred to the case of ZA. ZA is the case on surrender sing, which was helpful. That was addressing Regulation 9 and said that the Home Office have tried to change things and introduce this centre of life test. And the Upper Tribunal said there that the centre of life test is not part of EU law. And when looking at the genuineness, it's about whether there was a genuine exercise of treaty rights. So that's the key issue. So if somebody, often it's about going to Dublin. So if the British citizen has gone to Dublin, did they genuinely go to Dublin to exercise treaty rights? And was there a strengthening of family life during that period? But you can apply under the settlement scheme or under the EEA regulation, so there is provision there, and it would lead to a permanent right of residence or settled status. The Home Office don't like surrender sing, we know that, and they'll try and do anything they can to refuse those kind of applications. But I think in backing up your argument, have a look at ZA and the actual requirements of what EU law says, and the regulations don't fit with EU law. So that's my sort of thoughts on that question, definitely.
Anything to add, Priya?
Adam, there is a deadline for returning and applying under the surrender sing application scheme. I don't know it off the top of my head, but if whoever has posted this question, Lisa, wants to email either Adam or myself afterwards, we can look up that deadline. I don't think it is in line with the 31st of December 2020. I think it's a later date that they have to return to the UK and apply by. But as I say, we can check that and return to that individual if they email us directly, Lisa.
Okay, no problem. So we've got a delegate question here now. If an EEA application under the regulations is refused and the appeal is unlikely to be listed until after Brexit, who will, I'm struggling to see that, still be able to continue with that appeal? Will you, sorry?
I don't see any reason why not. Because as long as a decision is made and the appeal is pending, obviously, and EEA applications don't engage Section 3C, so it's not saying any, depending on what leave they had before, but they wouldn't need to leave. Whether you, as a tactical decision, make a settlement scheme application while you're waiting, because often settlement scheme applications are quicker to resolve and get you a quicker and more satisfactory answer. Obviously, I quoted Amari earlier. There may be tactical reasons why you're carrying on, but any decisions that are pending appeal, and we know, I think there's probably huge delays, both caused by a backlog because of Brexit and then coronavirus. Those appeals should still go ahead even after the deadline. That's my view. I don't know about you, Priya, in relation to that.
I agree. I can't see any reason why their appeal would have to come to an end.
Okay, what will be your next? Feeding through. How does the decision in PA Iraq impact upon the, I'm sorry, I'm really struggling to read this tests in deportation? Okay,
so I think that must be HA Iraq and RA Iraq. So if anybody has watched the session that I recorded, it was recorded at the end of August. And HA Iraq, RA Iraq was handed down on the 4th of September. So it isn't included within those notes. However, for anybody who has signed up to the sessions, a separate note has been sent summarising some of the useful paragraphs in that decision. But for present purposes, it's a decision that's really useful on the test of unduly harsh. Immigration practitioners that do a lot of deportation work will know that the test of unduly harsh, it was becoming more and more difficult to argue these cases, with recently cases in the upper tribunal giving the impression that it was only where a child had a diagnosable psychiatric issue that it was likely that the test of unduly harsh was going to be made out. Now, HA Iraq and RA Iraq really assists with trying to understand what unduly harsh means. And what it says is it's whether the harshness which the deportation will cause for the partner and or the child is of a sufficiently elevated degree to outweigh that public interest. And they go on to say in that decision that there's no reason in principle why unduly harsh may not occur commonly. So it's not the case that we're looking for something out of the ordinary. And I think that's really important, because when you look at some of the cases that have gone through the Court of Appeal in 2019, so everything really that's been handed down in between KO in the Supreme Court and this decision of HA Iraq, the cases in between, it's clear that the courts have been looking for something extraordinary. They basically have spoken about how a child being emotionally impacted, about how it's going to be difficult for a single parent will not be enough. And the Court of Appeal don't necessarily agree with that here. They say how a child will be affected by a parent's deportation will vary upon a range of circumstances. And part of the decision, they give a list of the factors that might be relevant, and that includes the child's age, whether the parent has been living with the child, the financial consequences of separation, the emotional support that's being provided by that parent, how practical it will be for that child to maintain any sort of relationship with the parent, the individual characteristics of the child. So it's a really useful judgment in respect of the unduly harsh test. Now, there's other really useful aspects of that decision too. It goes into great length about best interests of children, the importance of British nationality, how if the child's best interests haven't been taken as a primary consideration, that decision will be liable to be set aside. It also talks about the test of very compelling circumstances, and it makes clear that individuals aren't precluded on relying on children and partners, even if they haven't met the exceptions of unduly harsh. They can still raise all of that under the test of very compelling circumstances. It's really difficult to give a bite-sized analysis of that decision, actually. It's something that I could probably spend half an hour talking about. But Adam, is there anything else in there that you wanted to pick up on?
I think two things which you've sort of hinted at. I think the first thing is that A lot of those cases from the Court of Appeal were just saying, oh, and you see it all the time in decisions from judges, this is just an ordinary father-child relationship and there's nothing out of the ordinary. I think the Court of Appeal point out the danger in that approach is you're actually elevating it to an exceptionality test, that if you're looking at something out of the ordinary, you're effectively applying exceptionality. So I think it gives us an in on challenge, on firstly succeeding in unduly harsh cases, and secondly, challenging cases, perhaps where a judge has elevated the threshold. I think secondly, what you said about best interest is really helpful, that there's that short judgment at the end from Lord Justice Peter Jackson, who I think is a family judge by trade. So he's very focused on looking at the individual child rather than the hypothetical child. And I had a case the other day where the child had special needs, and in the determination, the judge were just looking at, well, it's just a father separated from a child. Well, it's not. It's this child with her particular needs. So I think that's really helpful, is the focus on the individual child is helpful. One thing to watch out for, mind, is if it's not at the undue harshness, looks at unduly harsh of the family being separated or the family going with. And if one of those is not unduly harsh, you won't succeed. So remember to address both scenarios, is a practical tip.
The questions are flying in now, both. So how can you best argue tax discrepancy cases in the light of the recent case law?
I think that's one for me from my webinar. Can I just come back to something we said earlier, because I'll forget otherwise. We looked at Surinder Singh cases. I had a quick look in Appendix EU. That date Priya was talking about was the 29th of March 2022, and if you have a look in Annex 1 of Appendix EU and the definition, because as you know, the way Appendix EU is structured, a lot of the detail is in the definitions, and it's the family member of a qualifying British citizen. So if you have a look, family member of a qualifying British citizen, Annex 1, 29th March 2022. So tax discrepancy cases, a lot of clients we've had over the recent years have had issues where they're tier 1 general applicants who've had their 2 periods of leave under tier 1 general and are now applying for indefinite leave to remain. Some have switched and are applying for 10 years indefinite leave to remain so they can get a right of appeal. So some who applied under tier 1 indefinite will only have administrative review, JR, and the appellants in Balajagari appeal were people who just had JR and then went up to the Court of Appeal, or they may have a full right of appeal before the tribunal because they've applied on a 10-year basis. They've usually had to provide high income to succeed under tier 1. And then what's happened is when they've applied for indefinite leave to remain, the Home Office are doing checks, and it turns out they've declared much lower to the revenue. Often before the applications have made, people have amended their tax return. And importantly, the revenue have accepted those amendments and taken the money. I'm sure they're happy to receive lots of extra money, but not imposed a penalty. Usually the explanation is there was a fault by a current or previous accountant. Now, Balajagari is the leading case in the Court of Appeal. That case talks about where the Home Office have not properly followed procedural requirements of giving an opportunity to provide an explanation before a negative decision is reached. And now there is a policy, and they should normally be writing out to give it for you to give an explanation. If you've got a right of appeal, the appeal will cure that procedural defect. So we know now these are Article 8 appeals, so you can't win on a not in accordance with the law basis. You've got this opportunity to provide your explanation at the appeal. And the case law I discuss in the webinar, very much what they've said now is that previously we've been relying on letters from accountants accepting errors, or perhaps new accountants spotting the errors of previous accountants. But I think now certainly there's a move, and there's a case from the President and also a recent case from so it's Abbasi, which is the case from the President, and then a recent case, Ashfaq, from Mr. Ockleton, very much focusing on the need to have the accountant there to give evidence. Now, sometimes it might not be an accountant's error, and you might be able to say, well, there is a proper explanation. But otherwise, if you haven't got that accountant's evidence, you may have difficulty succeeding. So I think I think certainly what you're going to need to do is provide a detailed explanation from your client and the accountant of how the error came about, how it was spotted, what happened in terms of the amendment, and in try, if possible, to get an accountant to come to court. Now, I appreciate that's going to be very, very difficult, and most accountants, especially with their own sort of professional liability, may not want to come to court at all. So I think there's definitely, as we saw over the passage of time with the TOEIC cases, there's perhaps going to be a toughening up from the tribunal in relation to that. There was another case I mentioned in the webinar, the Yassine case. That was one where the tribunal found that there wasn't dishonesty under 3225. This was one of a failure to do tax returns, but actually they still found under 276B, the long residence rule, that you fell in the character and conduct rule there. So even though dishonesty wasn't made out, they still were unsuccessful under that aspect. You can sometimes succeed even if there is dishonesty based upon, say, Article 8 children sort of aspects, but that's more difficult. That's much more difficult. One example to look at there is, I think, the Mansour case, which was a JR, but they'd succeeded and got discretionary leave. They were trying to argue they should have got indefinite leave, but they only succeeded in getting that because of the welfare of the children. And Priya, you mentioned to me when we were chatting about cases where they were trying to argue the case again because it happened before Balajagari. You had some experience or information in relation to that?
Yeah, so I'll just pick up on that and then I'll come back on a few of the points that you just mentioned, Adam. So there's a recent decision from the Court of Appeal in a case called Akram, where there's been an attempt to reopen a Court of Appeal case about 5 or 6 months after Balajagari was handed down, on the basis that the case was previously decided incorrectly, and that's demonstrated by the Court of Appeal decision in Balajagari. And what the court have said is that the delay was quite significant, but also in that particular case, that individual had another application pending for indefinite leave to remain in any event, and the evidence that he presented to the Home Office and the court in respect of the 3225 issues doesn't sound like it was very convincing. There are other cases where individuals aren't trying to reopen an appeal before the Court of Appeal, but they've lodged an out-of-time appeal from a judicial review which has failed, on the basis that the JR was incorrectly decided, and that's demonstrated by Balajagari. I know that there is a case that's due to be heard on that later this year in the Court of Appeal, so it'll be interesting to see what's been decided there. But Adam, you spoke just then about how accountants might be reluctant to come forward. In fact, in one of the decisions that's been handed down by the upper tribunal, they speak about how they will name them in the decisions and how they will refer the accountant potentially to their professional body. So one can see how they would be now really reluctant to provide any sort of evidence at all.
No, absolutely. And the first one, the Abbasi case, that was the one where it was the fake accountant's letter, wasn't it? So I think very much there's a focus, and judges are really alive to this issue now. So I think, yeah, no, I can imagine as a self-employed person going to my accountant, I can imagine what they over my dead body would they want to come to court, certainly. So I think they have got more difficult, and yes, there may be cases where you can still succeed in showing that there's no dishonesty, but I think they're going to become more difficult, and you're going to have to get the evidence, and that's difficult. Yeah. Okay,
shall we move on? Can non-EEA nationals still travel with their EEA national spouse to enter the UK instead of applying for the EEA family permit?
I was going to say just yes. The answer is probably yes. And there's a case on that. I think it was Mr. Ockleton's case where they said you can just turn up at the border and make your application for entry. Whether you would want to, and especially with the difficulties in traveling in a coronavirus world, and whether carriers would let you on, I think so. The answer is yes from me. But certainly it may not be the wisest thing to do, and you may encounter difficulties, especially, but it certainly is, you can do it, yeah.
Okay.
Just following up on what Adam said, I've just quickly had a look. The case that Adam is referring to is CO, Nigeria. It's a 2007 decision from Ockleton.
Yeah, that's the one. Yeah, cool.
Okay, I'm just going to go back to a pre-recorded one to Priya. How does the decision in RA Iraq impact upon the tests in deportation matters?
I think that you might have already asked me that one, Lisa.
Oh, I do apologise.
It is important.
Let's try this one then.
So it's worth thinking about lots. So if people haven't looked at Priya's webinar on the material, do that, because it's such an important case, game-changing deportation.
Let's try this one then, Priya. Does AM Zimbabwe make a difference in suicide risk cases?
Okay, that's a really interesting question. So the test that has been established through Papashvili and the Supreme Court decision in AM Zimbabwe is whether, on account of an absence of appropriate treatment in the receiving country, so the country that the individual is going to be removed to, or owing to a lack of access to treatment in that country, there would be a risk of serious, irreversible, or rapid decline in that individual's health, such that it would cause a substantial reduction in their life expectancy, or whether it would cause intense suffering. So I would most certainly argue that that test does apply in a suicide case because of the wording, substantial reduction. It's significant reduction in life expectancy that's used in Papashvili, but in AM Zimbabwe, they do talk about substantial reduction. And so I think that's most certainly relevant in a suicide case. What you would need is you would need medical evidence to show that there is a real risk of suicide in your client's case. Added to that, you need medical evidence from the foreign country, and I would say objective evidence to show that treatment for that individual's mental health is not available, or that it's not accessible. Now, that would mean by not available or accessible, it includes issues like the cost of it, the geographical location of it, whether or not their particular medication is available, and whether they would have to resort to some kind of alternate medication. You would also need to look at how that particular country approaches issues of mental health. In some countries, the way that they treat it is inhuman. And I most certainly have had cases where the objective evidence makes clear that spiritual healing, going to doctors that use methods like chaining and shackling is really quite common. So there may well be strong arguments around things like that. There's also issues like stigma, discrimination, ostracization, harassment with mental health to consider. What I would advise you to do is that if you've got that medical evidence and objective evidence, would be to instruct your medical expert in the UK and ask them to comment on how your client would cope if they were to have to access the sort of treatment that you have found would be available in the foreign national's home country. It may well be that your expert comes back and says, well, that treatment wouldn't be sufficient. That would lead to a rapid decline in their state of health, and it's very likely that that would highly increase their risk of suicide, and that's going to really assist your case. Now, there is a 2018 Court of Appeal decision, MM and MV Sri Lanka, in which there was an argument that the test in Papashvili had altered the test in suicide cases. And the Court of Appeal said they couldn't see how it made a difference. The test was always different, they said, in suicide cases. They were referring to the test set out in J and Y. Those of you that have attended our sessions will have seen my material which discusses those tests. However, that's a 2018 decision, and the Supreme Court have made a very clear decision in AM Zimbabwe as to what the test is, and I would most certainly argue that. Adams, do you have any further thoughts on that?
Yeah, I think that'll be interesting, won't it? Because the Home Office will certainly try and argue the sort of J approach, and you'll need to then, you know, in your representations, argue why the Papashvili approach should apply equally in suicide cases. I think what you say about country evidence and medical evidence is so important, both to show the treatment available, and perhaps getting the country evidence before the medical expert. I think that's really helpful, because the danger is sometimes medics will do their own research, and then you'll get a presenting officer at court or the Home Office in the refusal letter saying, well, the medic is not a country expert. So if you've got that country expert evidence or country material that you've got and you show the expert, they can then reflect on the impact to the mental health of somebody, if there's that stigma in that country or that way of treating people with mental health problems. I suppose the other thing, and I think you may cover this in your session, is arguing something like 276 AD 6, the very significant obstacles to integration, as perhaps a backup, because I think the danger is with Papashvili is to see it as an open goal. Even though it lowers the threshold, it's still a high test, isn't it? And still, so I think people still need to engage with it and perhaps look at Article 8's not just an easier accessible version of Article 3, we know that, but perhaps 276 AD and the very significant obstacles, especially in those countries, as you say, where there is stigmatization, you may have a backup argument there. But I think that's really helpful what you say about the country expert informing then the medical expert. Yeah, that's really helpful.
Okay, they're still coming in thick and fast. So can you share any case updates on adult dependent relative cases?
I can perhaps help on that a little bit. Obviously, adult dependent rules are out of country only. The Britsits case upheld the adult dependent rules as lawful, but did say you have to look at the subjective needs of your individual applicant. So if you're a woman from a certain area of Pakistan, you may only want female family members to care for you, and that might be something that impacts you and your ability to satisfy the ADR rules. There was this follow-up case then, I think I'm pronouncing it right, Rebelli or something like that also, which followed Britsits. But the adult dependent relatives, I think that's subjective element. In terms of in-country, obviously the ADR rules don't apply. You can argue it under Article 8. You've got the very significant obstacles to integration, but that doesn't really engage with family life. I'm instructed as junior in a case that's coming up. It's due this term, but there are some, it may be adjourned because of some health issues through council involved, but of a case involving your classic granny in the UK. So granny comes on a visitor, staying with children and grandchildren in the United Kingdom, has got medical health needs. So hopefully the Court of Appeal will give us some guidance on those Article 8 in-country cases where there's not the ADR rule and there's no, very significant obstacles, is not an easy fit. Obviously, then we're looking at medical evidence, treatment in the home country, but also like social work elements of the relationship in the UK, perhaps with children and grandchildren. I don't know about you, Priya, in relation to these ADR cases.
Just in respect of you saying, Adam, about adult dependents making in-country applications, usually after having been on visit visas, in my experience, in a few cases I've tried to argue Chickwam. Is that the approach that you've taken, Adam?
I suppose the only thing I worry about then is they'll look at it through the lens of would they meet the ADR rules. I suppose if I could show I could meet the ADR rules on return, I'd argue it. But if I couldn't meet the ADR rules, I'd stay clear of it, because the ADR rules are so hard to meet. If you had a clear case where there was nobody in the country to care, and even with money going back or, employing somebody, I think if you could show the ADR rules are met, then I may argue Chickwam. Yeah. Otherwise, I would push the ADR rules aside and try and argue sort of an Article 8 principles, I reckon.
Yeah, I agree with that.
Yeah, depending on who the judge is and getting a steer from them, kind of how you want to argue it.
Okay, so this is quite a lengthy one, but what are the effects of COVID-19 on HIV treatment in Zimbabwe? Would this, coupled with HIV treatment now due to the impact of COVID-19, for a failed asylum seeker, meet the health threshold under the current case law?
Okay, I'll take that, Adam, because it flows from the question that I previously answered. So I've already set out the test that was established in AM Zimbabwe and Papashvili, so I won't repeat that. There was mention there of the fact that the applicant that this relates to is a failed asylum seeker. So the applicant's status as a failed asylum seeker, an overstayer, an illegal entrant, it's not relevant under this test, under Article 3. Their status would be relevant if you were arguing their health under Article 8. Not so much under what Adam discussed, so very significant obstacles to integration. If that test is met, then there's no reference to an individual's immigration history. But if you're arguing it under straightforward Article 8 outside of the rules, then there will be regard to public interest factors, and an individual's immigration history will usually be a factor that's taken into account. And if it's as an overstayer or illegal entrant, it would be against them. But for these purposes in Article 3, it's not relevant. The individual here that is being discussed seems to come from Zimbabwe. By the name of the case, AM Zimbabwe, you will have figured out that that individual also comes from Zimbabwe. So that case itself involves an individual who was on ARV medication in the UK, was HIV positive, and his case was that he would be able to get alternate ARV medication if he was removed, but he wouldn't be able to get the medication that he was on in the UK at present. His claim has been remitted to the upper tribunal from the Supreme Court to see if he meets the threshold that's now been set down by the Supreme Court and in Papashvili. So just trying to break down that question, we would go back to what that applicant would need to provide as evidence to be able to show that he meets the test. So he needs medical evidence from his consultants and doctors in the UK to show what he's receiving in terms of treatment and medication. There then needs to be an investigation about whether or not he would be able to access that upon return. And then if he wouldn't, and he had to get alternative treatment or medication, what impact would that have on his health? Would it lead to that rapid, serious and irreversible decline? Would it cause intense suffering? Would it cause a substantial reduction in his life expectancy? Now, in respect of the impact COVID-19 has had on HIV treatment in Zimbabwe, it's not something that I have researched in advance. However, COVID-19 has severely impacted healthcare in a lot of countries. So it's very likely there's going to be objective evidence that's quite easily available to find on a Google search that shows that healthcare is harder to access and less available as a result of the current pandemic. And it may well be that that assists in making an argument at present. Adam, can you think of anything to add?
Excuse me while I cough a bit. I think COVID is obviously fast-moving situation, isn't it? And I think we need to, you get the most up-to-date evidence you can. I suppose certainly you can imagine in countries like Zimbabwe, whose health system was already, I was going to say a breaking point, but probably, always on the verge. You can imagine how coronavirus would have a negative impact on that. Maybe if there's local lockdown issues as well. So say in, let's give an example in Zimbabwe, if the main treatment centers are in Harare and Bulawayo and you live in a rural area, are there issues of accessing treatment because of local lockdowns? I suppose the difficulty is things may change by the Home Office making a decision. I think I get a lot of emails these days with people saying, "Oh, can I argue coronavirus?" So I suppose what Priya said absolutely holds, that it's getting that evidence to show that it has a direct impact on the case. So in this case, the impact to access, or perhaps even affordability, Priya, if a country, jobs are wiped out because of COVID situation, does it affect ability to access the treatment geographically, or maybe affordability? So I think it's getting the evidence to show that it's an additional factor, but certainly it's something I would look into and add in, because in a health case, it may well be a factor. And the Home Office, they're alive to coronavirus at the moment, so certainly it's something that could tip the balance in considering a case. So yeah, it's worth having a look at.
Okay, Adam, I think this one's next for you. Can you summarise the new changes to the student rules which have just been announced?
Yeah, absolutely. I think these came out after my webinar were out. So HC 707 introduced the new points-based system in terms of students. And actually, it's today. So from the 5th of October at 9 a.m., new student applications will be under these new provisions. So do look at that. If you made an application at 8:59 this morning, it would be, or before, it would be under the old provisions. Now, of course, part of the reason for doing this is because of Brexit. So this will cover EEA and non-EEA, although because of the transition period, in-country EEAs will only be able to apply from January. And if you apply for entry clearance and you're an EEA national, you will only get a student visa from January 2021. It's following the Law Commission's recommendation on simplification. So the way the immigration rules are moving now is to get a new appendix for each new category. So this has got Appendix ST for students, the adult students, and then under 16s is Appendix CS for child students. And then you've got 3 additional appendices even, Appendix ATAS, English language and finance. And the English language and finance one, I think they'll be expanded as the new PBS rolls out, and we'll cover, at the moment, they just cover student applications. There's obviously some changes to the eligibility criteria. So now you've got to have a CAS in order to apply. And if you don't have it, your application will be rejected. So it's some things to watch out for. Actually, helpfully, the 8-year time limit on studying postgraduate courses has gone. There is, like the new skilled worker route, it's 70 points, but actually the points mean nothing because they are fixed categories that you have to have. But there's a change in relation to English language, and that seems to be more now. You only have to show your English language once to the Home Office. There's more switching provision, so more people can now switch into the student route. And I think instead of saying what categories can switch, it just lists those who can't. So otherwise you can switch into it. So I think visitors, short-term students, and there may be one other that are excluded from switching. And in terms, it says here, I'm looking at the memorandum that accompanies the statement of changes. It says applicants who apply for permission to stay in the UK will not be required to provide evidence of maintenance funds when they've spent longer than 1 year in the United Kingdom. So some helpful stuff. Actually, that's probably the first place if people want to go away from this webinar and have a look, the explanatory memorandum to the statement of changes, because there's a few bullet point summary as to the changes, but that comes in from today. So have a look at that. Not yet really for EEAs, but there are some helpful changes moving forward and a bit more of a simplified approach. But importantly, in terms of the eligibility, you know, if you haven't got your CAS, it may cause a problem. And of course, there's a subjective genuineness test as well, like everything at the moment. And that's where we know the Home Office latch on to that subjective genuineness test is in there as well. So that's a summary of the sort of changes that have come in force and timely from today.
Priya, one for you now. What is the process for appointing a litigation friend in the FTT? Okay, so all right, I'm going to assume that this involves an individual who doesn't have capacity, so an adult who doesn't have capacity. So the starting point is having a look at the Mental Capacity Act 2005. That lists matters that have to be taken into account. Section 2.1 of the Mental Capacity Act 2005, that says that an individual lacks capacity if they're unable to make a decision at a material time in relation to the matter at hand because of an impairment or disturbance in the functioning of their mind or brain. It can be temporary, that disturbance or impairment, or it can be permanent. And there should be a medical expert report that addresses whether or not your client is considered to have capacity or not. Now, a litigation friend, their purpose is they're appointed to give instructions and to otherwise conduct proceedings on that individual's behalf. The tribunal procedure rules in the first tier and indeed the upper tribunal, they don't actually
address appointment of litigation friends. However, the case law from the Court of Appeal, this dates back to 2017, the case is AM Afghanistan. What that says is that the rules are flexible enough to allow for the appointment of a litigation friend for a child or an adult who doesn't have capacity where justice requires that. Whoever has sent this question in will also want to have a look at the case of JS. It's a 2019 upper tribunal decision, and it sets out guiding principles for appointments of litigation friends. It has a look at what the CPR says, and it follows that. And it says that what needs to be considered is whether or not the individual can fairly and competently conduct proceedings on the individual's behalf, and whether they have any interests that are adverse to those of the client. And in my experience, the way that these matters are addressed in the tribunal is that solicitors tend to write in and explain with the medical evidence that the client lacks capacity, that it's important that a litigation friend is appointed, and they usually say who they have found and how they're suitable. And then either on the papers or at a case management hearing or at the start of a substantive hearing, the court usually appoints that individual. I personally haven't had a case where an individual's been located and they've been thought to be unsuitable, but you can certainly see how that might arise. Adam, is there anything that you can think of adding to that?
Just a couple of things. I think some judges are like, oh, we don't do that, and they're a bit unsure of themselves, but usually they'll do it. And I think, as Priya said, if you can write in advance or raise it as a case management review hearing, that's worth doing. I've had some solicitors use the civil forms for doing them in civil cases. There is an older case, it might be referred to it in the JS case. It's a case called C, and it was a JR, it's 2016 EWHC 707, and that's worth having a look at. But I think the important thing to be aware of is, I think as a solicitor, if you have somebody who lacks capacity and you haven't got a litigation friend, technically you might be without a retainer, and it could cause you indemnity issues. So I think to cover yourself, it's worth doing. And I think that is definitely worth doing, even if you think, well, I've got instructions to the sponsor, or the most recent example I had was with older adult parents. So the son who was the sponsor in the case, who was a GP, in fact, he did it. But I said to the sisters, well, it's important for you to do it, even though you're taking instructions from him, to get it formally done by the court to cover yourself in terms of indemnity. But remember, there's a difference between lacking capacity and fitness to give evidence.
Yes.
And I think there are two. You may have a client that's not fit to give evidence, but has capacity to give you instructions. So that you might not want to call your client on the basis of that and deal with the case submissions only. Those who lack capacity will also be unfit to give evidence, but sometimes you could have that hybrid scenario, and don't get those two confused. What we're talking about is lacking capacity to give instructions, but you may have somebody who's not fit to give evidence, and there may be separate questions you need to ask your psychiatrist. I say psychiatrist is probably or your medical expert who's assessing capacity.
Okay, final question now. So when a tier 2 applicant successfully transferred to global talent visa, are they able to reduce their working hours to part-time? And will there be an income threshold which requires to be met at the time of settlement?
Now, it's one that it seems it's the last.
That's one to end on, isn't it?
Very specific question. I'm not sure we can answer that specifically on the webinar unless Priya's got. Let me ramble for a minute or two.
I'm trying to have a look online.
Obviously, global talent is the replacement for exceptional talent. It is now within Appendix W of the immigration rules. This is the one where you have to. It's the dual application. You have to have the body, and it's not like the endorsing body with the innovator. It's these, like the Royal Council or wherever, because these are these sort of high-end scientists, humanities, filmmakers, that in arts. These are very limited. I don't think when you're in global talent, then there is a restriction on the hours or a minimum number of hours you have to work. I don't know if there is with the global promise, It's a very technical question, this, but that's my thought. Obviously, these are they're very much the leaders in their field globally. This is not just, I dealt with it with a Bollywood film producer recently, and even though he'd won some awards, we looked at what was needed, and he needed to be nominated for an Academy Award virtually to get into that. So it's very much the high achievers. But I think it's a more liberal regime once you're in it, because I think the difficulty is getting in it. I don't know if that's given you enough time to find something sensible to say, Priya, from what I've been saying.
I mean, there is a really lengthy policy guidance document that I think would give all of the answers to the questions that have been asked there. But as Adam said, it's a really specific question. And I agree with you, Adam. I don't think there is a limit on hours. I looked at the issue a little while ago for a solicitor who had a client who was interested in that route. And I couldn't remember seeing anything in respect of a limit on hours.
I think once you're in it, it's a liberal regime, isn't it? And it's a quicker route to settlement. I think it's getting it and getting firstly that endorsement effectively stage, and then the second stage of getting leave to remain.
Okay, so unfortunately that is all we have time for today. Thank you for attending Law 2020. Online Immigration Law Shapes the Debate, sponsored by Trinity College London, CELT. Thank you to our expert speakers, Adam Pipe and Priya Solanki. Don't forget to join the solicitors group Law 2020 online community on LinkedIn to continue the debate after this live session and to be included in exclusive offers for the next time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. Feedback forms for the event will be sent out when this event closes. By completing this, you will receive your CPD certificate. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from the 2020 Distance Learning Catalogue. You can also visit our exhibitor profile for more information on Trinity CELT. I will stay on for a couple of minutes just in case there are any further questions. If you would like any further information, contact details, etc. Thank you, and again, have a great afternoon.
Thanks to everyone.
Thank you. Closing the event.